Hello, legal researchers. This is Alena Wolotira from the F.L.A.W. Gallagher Law Library, here to talk to you about preliminary analysis. What is preliminary analysis, you ask? Well, preliminary analysis are the steps that you take as a researcher before you actually jump into searching. Preliminary analysis is particularly helpful when you have a new fact pattern and you are either unfamiliar with the area of law involved, or you just feel like you need to pause and collect your thoughts in an organized way before you jump into your research. We're going to be using a method for this that I created called the F.L.A.W.S method, which is broken down into 4 steps. Facts: read the fact pattern. Law: frame the legal issues you see in the fact pattern. Wonder: engage your curiosity and think about what you already know about this topic and what you need to learn more about. Search terms: use the information you've gathered in the first 3 steps and generate potential search terms. I've boiled those steps down into this one sentence: facts and law are wonderful search terms. Facts and law are wonderful search terms, further shortened to F.L.A.W.S, which I think is apt because research is never perfect. Not only is it extremely difficult to look absolutely everywhere and find absolutely everything, but also you will never be given all the time in the world to conduct a satisfyingly thorough research and analysis. There will always be other deadlines and projects eating up your time. So your goal is to get good enough at good enough research. Research is a skill that you develop over time through both successes and, more importantly, failures. A successfully analyzed issue in a memo is generally the result of dozens of research leads that you follow to dead ends. If you can give your research process some structure and practice using your skills, you will develop areas of legal expertise, develop research instincts, and ultimately become a more efficient researcher. In any legal research assignment, you're going to have a set of facts that undergird the circumstance in which you're researching. Sometimes it'll be a one-sentence question assigned to you by a superior, and sometimes it will be a long narrative compiled from discussions with multiple people about an incident. We're going to practice the 4 steps of the F.L.A.W.S method by diving into the following fact pattern. I'm calling this fact pattern Alena and Annie's uncaffeinated misadventure, which could also be called a really rough day for Chad. Alena and Annie are UW Law librarians who are driving along I-5 in Alena's car from UW in Seattle to Olympia, where they're going to be speaking to the state legislature about the importance of making the revised Code of Washington accurate online. They stopped on the way at their favorite place, Starbucks, so that Annie could order a grande English breakfast tea latte with 1 pump of the honey blend and no other sweetener. They gathered their drinks, and while re-merging back onto the freeway, Annie took 1 sip of her grande English breakfast tea latte with 1 pump of honey blend and no other sweetener and exclaimed, "This is the most disgusting beverage I have ever had the pleasure of imbibing," and threw it out the window. Unfortunately, the latte was thrown through the open window of another driver, Chad. Chad jumped in surprise at having the hot beverage unceremoniously dumped in his lap, flinging hot milk and tea all over the inside of his windshield. Chad had slippery hands and an opaque windshield and lost control of his vehicle driving off the road and into an embankment. Chad's car is totaled. He suffered a mild concussion and he has minor burns on his lap and hands. Your firm represents Chad, and you've been tasked with figuring out which laws apply here and against whom Chad has a claim for damages, as well as what sorts of damages he can expect to receive. It's always good to give a new fact pattern a clean reading like we just did before you start to dive into your analysis. But now it's time to talk about step 1 of preliminary analysis, the facts. Facts are factual. So you can try to use the 5 W's to figure out what they are. Who was involved in the situation? What happened? When did the what happen? Where did the what happen? And why are you researching this issue? So in our Alena, Annie, and Chad situation, Who was involved in this situation? Pause to think about the parties to a possible case here. Okay. Hopefully the who's you came up with are Alena, Annie, and Chad. We can also add to the who's the roles that each of these people were playing. They were drivers, passengers, a latte thrower, victim. Those are other helpful terms that you can use later on in your searching. Moving on to what? What happened? To answer this question, try to consider the facts that are particularly relevant to figuring out the legal issues in this case. Much of your fact pattern is going to be included in this what. Pause and take a second to consider which parts of this fact pattern that you'd call particularly relevant to your analysis. Okay, here are the pieces I thought were probably relevant. The fact that they were driving, the fact that they were on the freeway, the fact that they were somewhere between Seattle and Olympia, the fact that Annie threw the latte out the window and that Chad's window was open, the fact that he flung the liquid and it went onto his windshield, and the fact that he crashed his car and has injuries, both personal and to his property. Another W. When? When did the what happen? As you can probably imagine, when has a lot of relevance to a legal fact pattern. Did this situation take place yesterday or 10 years ago? When can also include the sequence of events in relation to each other. This particular fact pattern is pretty sparse on whens, but I've taken a stab at identifying a couple. Pause and do the same. Here they are. The second to last W is where. Where did the facts take place? Thinking specifically about geographical location and jurisdiction. Why? Because the jurisdiction is going to matter very much for which laws are going to apply. Pause and think about the wheres in this fact pattern. I think the only real where we have here is I-5 somewhere between Seattle and Olympia. Okay, the final W of facts. Why are you researching this issue? This one's pretty self-explanatory since I give it to us in our fact pattern, but it's useful to understanding the framework and perspective from which you're conducting a research project. Your research path is going to change depending on if you are conducting legal research or seismological research, or if you're working for the State Patrol, the University of Washington as the employer of Alena and Annie, or as Chad's attorney. Here is the why from our fact pattern. Okay, that's all of the W's and thus the end of the facts portion of preliminary analysis. But don't worry, we're going to return in a second to talk about missing W's. On to the next step, which is law. The L in F.L.A.W.S is law. In this step, you're going to assess and frame the legal issues that you see in a fact pattern to help inform what you already know about the law as a basis for what you need to research. So, this is an inward step. Looking inward, reflect on what you already know about the law in your fact pattern. It's okay if you don't know very much. Starting from even the most basic of analyses here, whether this is civil or criminal, can be helpful in narrowing down the areas where you're later going to search for your research. I hope that it's somewhat reassuring for you all to know that in the reference office, where I've worked for 15 years, I get new fact patterns every day. Even as a legal researcher with that much experience, having gone to law school and helping people with research for such a long time, I don't always know what the law is that governs any given situation. I use my knowledge from going to law school and passing the bar exam to inform my research choices, but I typically don't know either what the answer is legally or even where I'm going to find that answer in the law until I start to dig in. We all know things, especially after the foundation of the first year of law school. But even if you have not had the opportunity to go to law school, you've heard enough about the law in the news or seen enough Law and Order to have a good starting point. You want to have a good starting point that can situate yourself in the law and figure out generally what area of law is going to be most likely to be helpful for us to focus in on. This is also where secondary sources can come into play, and we'll talk about those at length in future lessons. In conducting a legal issues assessment, I like to start to think about what I know and what I don't. When I'm thinking about which law would apply in a preliminary analysis scenario, I like to ask two questions related to big topics in law. First, which, if any, of the first-year law courses, that would be civil procedure, property, contracts, criminal law, constitutional law, torts, are most likely relevant to the facts in this situation. And the next one is, are there any other big legal subjects, ones that I've either taken a class on or heard of that I think might be relevant? I just list them out. I'll use these later to help filter and narrow down where I search. In our scenario, which of the 1L classes, which of the major classes you take as a first-year law student is going to be most relevant to Annie, Alena, and Chad's situation? Pause to think. I think this one's pretty obvious, torts. This is pretty clearly someone, namely Annie, exercising a lack of care, and someone, Chad, experiencing a legal wrong. How about other courses? Motor vehicles law, that's not really a class, but there might be something specific to motor vehicles here. What about employment law? If Alena and Annie are considered agents of the University of Washington, that might have some relevance. Maybe community property. What if Alena or Annie or Chad are married and we're in Washington state, and Washington is a community property state, and I know that there's some rule about whether or not community property can be called in as the property of a tortfeasor when determining damages and liability. I don't know, maybe there's something there. After thinking about this, I think the most obvious two areas that we could hone in on for now, and you can always come back, is torts and employment law. Our third step in preliminary analysis is the wonder step. In this step, we're going to pause to engage in a little mental exploration. We're going to first wonder about what we already know about this area of law, then think about what we're missing from our facts and our understanding of the law in this area, and then try to fill any essential gaps that we can before we move on to the last step, which is searching. So the first part, wondering about what you already know about this area of law. In our fact pattern, I'm relatively certain that this is going to be a tort. We're talking about damages. We're talking about someone doing something that caused harm to someone else. So what do I already know about sort of this area of law? I know that littering in and of itself, like throwing something out of the window of a car that's garbage or, a disgusting drink, is pretty bad. That's unlawful. I also know from torts generally that we owe duties of care to the people around us depending on what we're doing. So I'm guessing there is some duty of care owed by one driver or the passenger of a car to other drivers on the road. I'm wondering if perhaps it's negligent or maybe even worse to throw something on the road when there could be someone else there. I also seem to recall a case from first-year torts where there was something having to do with fireworks and the train about reasonable foreseeability. I think the case was called Paul's graph. So that's something to think about. And then finally, since we know that this is a Washington situation, I am guessing that there are going to be Washington-specific flavors of the law here that I'm going to need to be aware of. Wondering about what we're missing. What are we missing in our facts? What are we missing in our legal understanding? So if we think about our situation, let's go through the 5 W's again. What are we missing from each of those factual queries? So who? Are we missing any who's? We have Alena, Annie, and Chad, the driver, the passenger, and then the other driver. Is there anybody else who's missing? I think we may be missing a who in who is Alena and Annie's employer. Perhaps that employer needs to be included. It would certainly be relevant if there was anyone else in the car with Chad, if there were other drivers on the road. Maybe there was a police report filed. I mean, Chad did crash, so I'm assuming the police got called. And if so, an officer who came to the scene would be another missing who. What? Are we missing any what's? I think we're probably missing a lot of what's. And some of these we're going to be able to easily fill in the gaps, and some we may never know. Why was Chad's window open? Depending on the time of year, it might have been odd for Chad to have his window open on the freeway. How much are Chad's damages? If Chad's car was worth $15 and he totaled it, and Chad, had a few bumps and bruises, then perhaps if we're thinking about lawyering as a profession, the missing what of how much Chad is likely to recover is too low for us to pursue this case. Were Alena and Annie on official business? I know has some relevance to whether or not the University of Washington as their employer could be pulled in as a possible party from whom Chad could recover damages, or were they just having a lark? I seem to remember from business associations that if you are doing something in the course and scope of employment, it's a lot easier to pull an employer in, whereas if you were off the beaten path doing your own thing briefly before you return back to the course and scope of employment, then that is less likely to be behavior imputed to the employer. I think another big what was in Annie's drink? Was it just not made correctly? Were there, 2 pumps of honey blend instead of 1? Or was the milk bad? Did something go seriously wrong with the drink such that perhaps Starbucks may have some responsibility here? Other missing what's. I think this is probably less likely given the facts that we know, but it might be relevant as to whether or not the person who caused the harm, Annie, and the person who was harmed, Chad, had a pre-existing relationship. Say, what if Chad and Annie had previously been married and were now divorced? It was an acrimonious divorce, and Annie actually saw that Chad was on the road, and she threw her beverage purposefully through his open window in order to create chaos in his life. Or perhaps Chad was a puppy, and Annie is Crew Annie DeVille and has been plotting to rob Chad of his luscious fur. When did the what happen, and are we missing any whens? We're really missing all of the whens. The only thing we have in the fact pattern is that Chad came to you to talk about this having happened. This is relevant because obviously if this took place 10 years ago, statute of limitations might have run. There might be nothing that Chad can do. What time of day did this take place? It would be one thing if this was in the middle of the day and where visibility was high. Annie and Alena could have easily seen other cars on the road. Or in the middle of the night, it might have been easy for Annie and Alena to see another car on the road that had their lights on. But if it was dusk and maybe lights weren't on, maybe it would have been harder or less reasonably foreseeable for Annie to throw that drink out the window and hit Chad. And then finally, what facts on the page could lead me easily to other facts? So one thing I was thinking is we know that Alena and Annie were heading to Olympia to give testimony to the legislature. that testimony is all going to be in the legislature's records. So we could pretty easily look up when someone named Alena gave testimony on a topic related to the RCW in front of the Washington State Legislature. And that would be obviously a good day to start with when we're thinking about when this took place. Finally, where? Are we missing any wheres? I think we are missing a major where, because the fact pattern doesn't actually tell us where exactly this accident took place. Once you've gathered a list of facts that you're missing, then you can start investigating to see where you can find more information, either from the parties or by doing easy, simple investigation to try to fill essential gaps. Filling these gaps is going to make your search terms far more solid and your results far more on point to what your specific situation is. So let's say in our fact pattern, we did this. We filled some gaps. We got the police report. The police report demonstrates that the accident took place in Pierce County right after exit 130 in Tacoma. Okay, we've got a where. We know what our jurisdiction is. You spoke to Chad. Chad is your client, obviously. You asked him a few questions. One of those was, did you and Annie have a pre-existing relationship of any sort? And Chad reported that no, they did not know each other. You took a look at the legislature's website and found that it matched the date of the police report, February 12th of this year. Alena stated in her testimony that she was speaking to the legislature in her professional capacity as a law librarian at the University of Washington School of Law. That's another helpful gap-filling fact that lets you know that it is more likely that Alena and Annie were on official UW business when they were driving to Olympia than if they were just off doing this in their personal capacity because they happen to love the RCW. We're going to need more gaps filled, and you're going to have to consider whether or not any of these are just going to need to wait until perhaps you're actually into litigation when you can depose the other parties. So now that we have our facts, our law, we've wondered, we've filled in some gaps, we are on to the search term step. This isn't about searching itself. This is about gathering good search terms so that when you go to engage in your search process, you have solid information that you can use to build the foundation of your research. So you're going to start with your best guess about relevant terms from all of the other research that you've done so far, from all of the other analysis that you've done so far. So I went back and I collected the terms that I think are most likely to be relevant to the situation. So from who, employee, driver, passenger. What, vehicle, litter, liquid, obscured windshield, thrown item, road, accident, damages, lark. When, I think when is less relevant for searching. You just need to know whether or not there's going to be a statute of limitations, and that is that's not part of searching unless the when involves a longer time period, in which case your search terms are going to be relevant to whether or not there's a statute of limitations. The where, Tacoma or Washington, we'll leave that out of our searching for now. There's going to be a statute or some case law that will have to do with how do torts work in Washington state. And then from the law step, negligence, tort, we're pretty sure that this has to do with a tort. And then from the wonder step, we found out a little bit more about Alena and Annie's relationship to the University of Washington and their testimony and their trip that day having to do with their professional work at the University of Washington. So I'm going to add the search term of employee. So our search terms that we've already generated from the fact pattern might need to expand a little bit. And that is because there can be different terminology depending on the jurisdiction for the same concept. A tort is also called a civil wrong. A vehicle is called a motor vehicle or an automobile. Just, all of those sorts of things that when you go to run your search, depending on the sophistication of the database, you may or may not get false dead ends because your search terms did not match what the terminology is for that jurisdiction's legal principles. So I think it's a really good idea to generate some synonyms for your search terms, just so that you can really cover all of your bases. And the way that you do this is by using a legal dictionary, a regular dictionary, or my favorite, an AI tool to generate synonyms. So let's start with the first word, object. Object is pretty vague. It's describing litter, but it's just a thing, So I wanted to see if perhaps the Oxford English Dictionary had some other alternative terms for the word object that may be more useful to us in our searching. So here are the synonyms generated by the Oxford English Dictionary. My favorite of which is thingamy. I think that's British English, thingamabob, thingy, thingamajig. I don't actually recommend using any of these terms in your searching, but I do think that perhaps item could be useful. Most of the other things are a little too silly and are likely not going to be, included in an RCW definition of litter. So I think not so great, but worth a try. I also tried using an AI tool to generate synonyms, and AI tools can actually be really helpful here because you can give AI some context so that the synonyms that it generates are far more well attuned to why you need these synonyms. You're not going to get thingamajig for object because AI is going to obviously understand that you're not looking for whimsical words. Right. So here's my prompt to Claude. I'm developing search terms for a case law research project. Please provide me with 3 synonyms for each of these terms. And here's what Claude came up with. I'll let you pause and read through its suggestions, which seem to be, to me, far more legally oriented. And here's the ones that I chose to add to my list of search terms. So automobile, to add to vehicle, debris. I think that's probably the most useful because debris to me means something that isn't supposed to be there that can theoretically get in the way. Duty of care, due care. I recall from employment law or business associations that originally where the employee and the employer have a legal relationship that used to be called master-servant. And then obscured windshield, impaired visibility. That was really the issue, I think. Although, I think Chad's issue was more with being distracted by being covered in hot beverage rather than not being able to see through his windshield. So bringing it all together, here are all of the terms that we generated from the fact pattern. Those are the first terms listed in each of these numbered items. And then in addition is all of the additional synonyms that were added by both the dictionary and by Claude. So I've bolded the ones that I think I will actually use for my searching. And then the next step is obviously to put these into a good search string and go and conduct your searching. But the bolded terms here, these are our search terms. They are going to help us hone in on the area of law that is relevant to this fact pattern. So you did it. You conducted a preliminary analysis using the F.L.A.W.S method. Well done. Time to practice and start some search.